Lord, I'm grateful for the time you've afforded me to consider matters. I've nothing further, so unless anything's occurred to your lordships over this short adjournment, I'll sit down.
Only 10 questions.
Just 10, I'll deal with them in writing, my lord.
Mr. Kings.
My lords, my lady, we say this appeal should be dismissed for the reasons given by the judge. The case that's before the court looks a lot like from an undergraduate contract law examination. It gives rise to three fundamental issues of contract law. Firstly, whether Camelot's terms were incorporated into the contract. Secondly, whether those terms were enforceable. And thirdly, on their true construction, did the claimant win the £1 million that she's claiming? I propose to address the court in that order. But before doing so, I propose to start by briefly explaining what went wrong with this instant win game when the claimant played it on the day she did in August of 2015. Now, the starting point, as your lordship and my ladyship are now familiar, is that instant win games are games of chance. They require no skill or judgment from the player. The outcome of every instant win game is decided by Camelot's computer system at the time the ticket, which is referred to as a play in the terms, is purchased. At that point in time, the player's wallet is debited with the price of the play, and Camelot's computer system decides whether or not a prize has been won, and if it has, in what amount. The player then proceeds to play the game, the animations of the game, on their computer screen or mobile device. Some games, like the one that is the subject of these proceedings, require the player to click on icons to reveal matching numbers or captions. Others take the form of a virtual dice that is rolled or a roulette wheel that is spun. But in all of these games, the outcome has been determined by Camelot's computer system before these animations are presented to the player. And what the animations ultimately reveal doesn't affect that outcome, doesn't affect the outcome that has been predetermined by Camelot's computer system. As the judge summarized it in paragraph 24 of his judgment, at the point of purchasing the play, the die is cast. Now, Camelot's evidence about how these games operate is contained in the witness statement of Mr. Smith, which we've looked at earlier today. That's in the supplemental bundle, my lords and my lady, behind tab A4, starting page 22. On page 29, Mr. Smith gives evidence about the play sequence for all instant win games, starting at paragraph 34. The key points are these. Firstly, paragraph A, the point of purchase for the play is when the player clicks the play button. B, over the page, at that point, a random number generator selects a number. That number corresponds with a prize tier. Each prize tier corresponds with a prize amount. The number that is selected by the random number generator therefore determines the outcome of the play. And all of this happens before, a nanosecond before, the animation files are selected. And then the final sentence of that subparagraph, the subsequent selection of the animation files does not change the number selected by the random number generator.
That's the point about it doesn't matter which sequence, for example, you press the numbers in.
That's right, my lady. He goes on in paragraph 35 to deal with the play that is the subject of this claim. he says that the random number generator selected a number corresponding with prize tier 27. That amounts to a prize of £10. And the random number generator therefore determined the outcome of the claimant's play as a prize of £10. That is the outcome that is recorded in Camelot's database, in Camelot's official list. It was in evidence before the judge. It's also before the court now. If your lordships and your ladyship turn behind tab A5 to page A149, you'll find there an extract from the database setting out the ticket number for the play in question. And then about 2/3 of the way down, ticket status 1, prize status paid, prize tier 27, prize value £10. The game that is the subject of the claim was called 20 Million Cash Spectacular. It went live on the 25th of August 2015. That's the day of the relevant play for our purposes. Unfortunately, it was the subject of a coding error. My learned friend has already taken the court to paragraphs 37 and 38 of Mr. Smith's witness statement, which explain that error. The error was isolated to the animations associated with the game. It didn't affect the numbers selected by the random number generator. And as my Lady Justice Andrews pointed out, how the error manifested itself differed depending on the device that the player was using. So if the player, like the claimant, was playing the game using a PC, they would see an erroneous number 1 in the Your Number section on the gameplay window. And we see that in the screenshot that we've looked at on a few occasions today. Had she been playing a mobile device, she would have seen a blank instead of a number 1. And there is a depiction of this behind tab A5, page A150. It's also possible, because the animations are not a necessary element of instant win games, for them to be disabled. Had she disabled the animations after she had clicked play on the game details screen, and I'll show you that screen shortly, she wouldn't have seen any animations at all. She would have been taken directly to the outcome screen. And an example of this appears at page 126 in the same tab. Now this is an outcome screen for a different game, but it would have been materially the same. Congratulations, you have won £10 on Festive Lines Gold. We've paid £10 into your account. And the player would have seen this outcome screen if they had enabled the animations after they had clicked finish on the gameplay window. So this is the final screen in the player's journey of playing the game.
Sorry to interrupt. So if you disable the animations, for whatever reason, and you press the start button, then the computer does it all for you.
Correct.
So you don't even go through them.
And my lord, this goes back to the fundamental premise of these games, that the animations are an unnecessary overlay for entertainment purposes only. The outcome of the game has already been decided by the time that the animations are fetched by the computer system. I propose now to deal with the incorporation issue, the first fundamental issue. There are two strands to this issue in my submission. Firstly, the incorporation of Camelot's terms generally, and secondly, whether any of the terms relied upon by Camelot are onerous or unusual, and if they are, whether those terms were incorporated. On the general issue of incorporation, we say that the position is clear and there was no error in the judge's decision. I'll show your lordship and your ladyship briefly what the claimant saw and agreed to, and none of this is of course in issue for the purposes of the claimant's summary judgment application. When the claimant first opened an account on the National Lottery website in 2009, she was presented with the screen that my learned friend has already taken you to at page 84 behind tab A5 in the supplemental bundle. I don't propose to turn that up again. Camelot's terms were updated from time to time. The evidence shows that this happened before the game was played on the 1st of September 2014. The next occasion that the claimant would have signed into her account on the National Lottery website, she would have been presented with the screen that one sees behind tab A5 at page 118. This explains that the terms have been changed. There is a summary of the changes. These are drop-down menus. If one clicks, one sees precisely what has been changed. You don't have to read the rules all over again, as my learned friend admitted to you. And there is a hyperlink to see the full account terms and rules. Unless the claimant had clicked I accept, she would have been signed out of her account and wouldn't have been able to play the game. On the day that she played the game, the first screen that she would have seen...
Just before you do that, can you
Yes, my lord.
can you help us with this?
Yes.
Do you know from computer records how many people actually access the rules, and if so, do you know how much time they spend on them? In other words, can you deduce whether they read them or not?
Okay. I have representatives from Camelot behind me. I'll ask them to give me that information at a convenient time. They might need to ask some questions themselves. But I don't have that answer.
Normally you can judge the amount of time a particular page is being accessed: a minute, 2 minutes, 5 minutes, 5 seconds, and so on. I'm just interested. I mean, it may be that this is not really relevant. Maybe common sense provides the answer that most people don't read them, but I don't know if that's challenged or if it's said that Camelot is advancing a case that they are read. I mean, it may just be that everybody accepts that. I mean, I think we accept that traders have got to have a way of presenting their terms and conditions, and this is where the whole issue of how you strike the balance arises. But
yeah, I'm told, my lord, that Camelot can't see how much time has been spent looking through terms and conditions. It's not data that is stored in Camelot's repository. But I dare say that your lordship is right, that very little time is spent looking through these terms and conditions.
You would say that's all the more reason why one has the unfair contract terms regulations to redress the balance. So because it's common knowledge that even if the consumers did spend hours looking over it and even rang their lawyer to ask what it was all about, ultimately it's one-sided because they can't ring up Camelot and say, I don't like clause 12.1. Can you take that out, please?
Correct. In my submission, my lady, and we'll come to this, there are two techniques that the law employs in order to redress the situation. The first technique is the way in which we deal with the incorporation of onerous or unusual terms. They need to be specifically drawn to the other contracting party's attention. And the second tool in the toolkit are the 1999 regulations, or as we now have it, the 2015 Act.
Yes.
So on the day that the claimant played the game, before seeing the screen that we've been looking at, the screenshot, she would have seen what's called the game details screen. So we see this behind tab B6 in the supplemental bundle. So this is the game details screen. If one were to click the play button, one would go to the screen with the icons, and then you start clicking through the icons if you have the animations enabled. Just pausing here, this is the last moment in time that is pre-contractual. As soon as the player clicks play, we move from pre-contractual into post-contractual. Much weight is placed by my learned friend on the words that he refers to as the relevant contractual term. He said in his submissions that they were specifically drawn to the claimant's attention, that they were signposted. I don't dispute that one sees them quite clearly when one gets into the animations of the game at the bottom of the game screen. The only time that they appear in a relevant and pre-contractual sense is if one looks at the two images that one sees in the top right-hand corner, showing what the game is going to look like after you've clicked play. You can just about make out the words at the bottom. Match any of the winning numbers, and you win a prize. That is the signposting that he's referring to.
It doesn't say a prize or the prize, it just says win prize.
Win prize. Yeah. Sorry,
Whatever that means. Yeah. No, we read that and we had that very clearly in mind.
Yeah. Now, if one were to, if you see that there's a halfway down the page that says game procedures including how to play, if one were to click that is a drop-down menu, and that would open up the game procedures. The game procedures appear as they would have appeared to the claimant in the core bundle behind tab A10, starting page A144.
Sorry, page A1, after tab 10.
After tab 10,
144.
144.
Yes, thank you.
So if you can imagine that this is we're still in the game detail screen here. All that has happened is that somebody has clicked the drop-down menu, and the game procedures therefore appear underneath that drop-down menu. And the first paragraph says, these are the game procedures. When you play the game, these procedures, the rules for interactive instant win games, and the account terms apply. All of these documents can be found on the National Lottery website. You might be able to work out with the colouring of the text that those are hyperlinked. So for instance, if one had clicked the rules for interactive instant win games, one would be taken to the document that starts at page 130. Now, the judge held that, subject always to the question of onerousness, these various techniques were sufficient to incorporate Camelot's terms into the contract. And in my submission, he was right about that. He properly directed himself by reference to the general principles of incorporation set out in Chitty. He did that in paragraph 43 of his judgment. And he concluded that Camelot's terms were incorporated by reference. We say that the claimant's challenge to this part of the judgment should be rejected for two reasons. Firstly, the claimant's argument on this issue proceeds on the premise that the general principles of incorporation that are set out in Chitty don't apply to consumer contracts. And in my submission, that's an entirely false premise. In many respects, these principles are derived from consumer contracts, including the 19th century ticket cases, like Thornton and Shoe Lane parking. As my lady...
20th century, because it's all about a machine.
20th century, excuse me. 20th century. As my lady Justice Andrews pointed out, whether one is dealing with a parking ticket or a consumer contract that is concluded online, the issue that the law is facing is really the same, which is, has the trader, has the person who is seeking to rely on its terms and conditions done enough to draw those terms and conditions to the attention of the other contracting party? The second reason...
Does that take account of the nature of the other party, so that what might be required in the case of a consumer may be different to the case of a sophisticated forex trader? Or do you say it's a flat line?
In my submission, it would be wrong for this court to start bringing into this particular issue questions of the characteristics of the consumer. There are other avenues that are available to us in order to redress the balance. In my submission, there is nothing difficult or wrong in principle applying the general principles of incorporation that are set out in Chitty to consumer contracts. And as I've said, those principles developed from consumer contract cases. The incorporation of terms is really an issue of fact. It needs to be addressed on a case-by-case basis. And in my submission, the court should specifically reject the claimant's argument that for all consumer contracts that are concluded online, the supplier's terms will only be incorporated if the consumer is required first to scroll slavishly through those terms before clicking I accept. No good reason was articulated for that inroad. And I suspect that many of us have experience of scrolling rapidly through such terms without paying attention to them before we confirm our agreements to the same. The consequences of such a decision, if my learned friend's submission were accepted, would obviously be enormous. The courts would become inundated with claimants arguing that they aren't bound by a particular supplier's terms because all they did, like Miss Parker-Grennan, was to tick a box, and they weren't required, first of all, to scroll through the terms. And in my submission, although my learned friend disagreed with me on this, this would introduce an entirely unprincipled distinction between contracts that are entered into in the real world and contracts that are entered into online. When one goes into a car park, you don't have to be marched up to the notice board that contains the terms and made to glance at the terms in order for those terms to be binding. My learned friend referred to the example of the archetypal example of a contract that contains terms and conditions that you sign at the end. But that's only one way in which a contract is concluded. Often terms and conditions aren't contained or aren't contained in full on the document that is signed. Often there is an incorporation by reference to terms and conditions that are available on our website. And when those contracts are signed in the real world, there's no suggestion at all that one needs to do is to visit the website and to scroll through those terms before they can have any binding effect. I propose now to turn to the issue of
Just
onerous...
looking at, I mean, I was looking at, just going back to Ebury and its reference to chitty on contracts and what's viewed as the normal practice. So this is tab 14 of the authorities.
Yes. I think, my lord, that Mr. Justice J sets these principles out in his judgment. These are the same principles that he relies upon. He does so in paragraph 43.
Okay, I mean, I'll look at that. Does he cite?
Yeah.
I mean,
He repeats it word for word. Paragraph 7.
paragraph 7, so which contains subparagraph 3 on notice. The party tendering the document did what was reasonably sufficient to give the other party notice of the conditions, and if the other party knew that there was writing or printing on the document but did not know it contained conditions, then the conditions will become the terms of the contract between them. So the gist of it is, did Camelot do what was reasonably sufficient to give the other party notice of the conditions? Is that a black and white rule, or is it context specific, which could therefore vary as to whether you had a sophisticated counterparty or a consumer? I mean, I understand your point that actually the brunt of the analysis should come subsequently on fairness, and I can see the disputes over incorporation. It could be a futile exercise if, in fact, the analysis operates in a different way. It comes later. The point made against you is that even terms which are not in... Well, anyway, okay.
What I struggle with, my lord, is if one has a situation like this, where what Camelot says is, our terms and conditions are going to be binding. You can access them here.
Yep.
Here are hyperlinks. If you click the box, you confirm your agreement to being bound by those terms. I find it difficult to accept any suggestion that there is a sliding scale in that analysis. I can't imagine a situation where you have one extremely unsophisticated consumer who ends up ticking the box and says, I just didn't understand.
Yes, I mean, you could do it by generic class, I mean, a consumer. But I mean, I understand the point you're making. And we understand that the traders have got to have some way of bringing their contract terms to the attention of consumers, and that in a digital world it isn't easy. So that's understood. The question is where the balance is struck, whether it is in terms of fairness or whether it's at a level of incorporation as well.
Yeah. Well, shall I move on to the question of onerous and unusual?
Just before my learned friend does, well, I'm so sorry to do this. I'm afraid I wasn't terribly well overnight. Could I just invite the court to allow me a short comfort break?
Yes, of course.
Why is the very...
I don't know what it is about this case that makes me ill. It's not the first time. I can only apologise. I won't be very long.
No, don't worry. Take your time, James.
But we'll leave the live streaming as a very short break.
It's funny how different sell tickets that 16 cents with campaign budgets. Those things
Council, are you all ready?
Yes, I'll just put my hat on.
Court rise if you're able to.
My Lord, I'm very grateful. Thank you
Mr.
very much.
Cowser, you're under no pressure. This is your appeal. If you feel ill, and you want us to adjourn tomorrow morning, we will. Please sit down, everybody. We will.
I know you will, my lord, and I'm very grateful for that indication. I think I'm going to be absolutely fine now. I was absolutely fine this morning.
Yeah. But I think we all know this bug going around. It's not nice, and it can be very sudden and debilitating. So, you know, if you feel ill, just let us know, and we will adjourn till tomorrow morning.
Certainly, I will let you know if matters
Yes, and
deteriorate.
don't hold back.
No, I'm going to sit down now, my lord.
Okay. Yes, Mr. Hinks.
Thank you, my lord. On the issue of whether any of Camelot's terms were onerous, the judge properly directed himself as to the applicable legal principles in paragraphs 53 through to 58 of his judgment. A high hurdle has to be passed for a term to be held to be onerous. Whilst some of the cases use different language, harsh, extortionate, draconian, the two leading Court of Appeal cases on this issue, the Interphoto case and the O'Brien case, both state the test as onerous or unusual, and that's the test that the judge applied here. When addressing this issue, the judge referred to the decision of this court in O'Brien and MGM. And I'll invite your lordship and your ladyship to turn this up, because the facts aren't a million miles away from the present case. It's in tab 3 of the authorities bundle. The facts are set out in paragraphs 3 through to 6 in Lady Justice Hale's judgment. So the claimant bought a copy of the People newspaper. It came with a card. His card revealed two sums of £75 and two sums of £50,000. He telephoned the mystery bonus hotline number published in the newspaper and heard a recorded message that the mystery bonus cash amount for that day was £50,000. So not surprisingly, he thought he'd won that amount. He had difficulty registering his claim because no fewer than 1,472 people were making the same claim. Somebody had blundered. In paragraph 5, you see towards the end, the first instance judge, the trial judge, found that it was intended there should be only one winning card for £50,000. But paragraph 6, unfortunately, the man at Europrint had failed to take into account that a large number of cards had already been printed and distributed. So in order to try and get out of this mess, the newspaper company relied upon the clause, Rule 5 of the applicable rules, which one sees at the top of page 36 of the report. On the next page, should more prizes be claimed than are available in any prize category for any reason, a simple draw will take place for the prize. The claimant's argument is summarised in paragraph 16. His counsel emphasised that Rule 5 turns winners into losers. He refers to the tagline or slogan, which said, match two identical cash amounts you have scratched off on today's section of the card. You win that amount. And one sees that those words aren't a million miles away from the relevant contractual term in this case. And his argument was that Rule 5 was onerous and it wasn't therefore incorporated. Lady Justice Hale's decision on incorporation starts at paragraph 20. She refers to the Interphoto decision, and then she says in paragraph 21, in my view, although Rule 5 does turn an apparent winner into a loser, it cannot, by any normal use of language, be called onerous or outlandish. It doesn't impose any extra burden upon the claimant, unlike the clause in Interphoto. And your lordship and your ladyship will remember that in that case, it concerned photographic stills, where you were entitled to retain them for a 14-day period. If you held them on for longer, you incur a charge of £5 per still. That was the onerous clause in that case. And Her Ladyship goes on to say it doesn't seek to absolve the defendant from liabilities for personal injuries negligently caused, like the clause in Thornton and Shoe Lane parking, merely deprives the claimant of a windfall for which he has done very little in return. And she goes on in paragraph 22 to say that the clause wasn't unusual. Now, applying these principles, we say the judge was right to find that none of the terms that Camelot relies upon in these proceedings is an onerous term. There are three categories of terms that are challenged by the claimant. In the first category is Rule 3.1 of the IWG rules. These appear in the core bundle behind tab 10, starting page 130. And clause 3.1 appears on page 132. We've seen this before today. There is, in my submission, nothing onerous about a clause that explains that in a game of chance, the outcome is determined when you buy the ticket and is not affected by any skill or judgment. The specific complaint that is made is that it is unclear what predetermined, the word predetermined means in this context, and that without the benefit of Mr. Smith's witness statement, one cannot know how that operates. In my submission...
What's the relevance of clause 3.1 to the actual dispute?
What's the relevance?
Yeah.
Probably very limited.
Okay. I mean, given the given the uncertainties that surround this area, I doubt we're going to delve into all sorts of matters just for the sake of it. I mean, as we understand it, we've got the tin, as it's called. We know what words are on the tin. We can construe them. We can decide if they're in doubt. If they're in doubt, we can construe them against you.
Yes.
If they're construed against you or in your favour, then we have to ask whether they are unfair. Well, A, incorporated, B, unfair.
Correct.
So how does 3.1 bear upon that?
Well, what all 3.1 does is to explain that this is a game of chance and that the outcome is predetermined.
Yep.
In terms of the contractual impact on this particular dispute, in my submission, it's very limited.
Okay.
So I'll move on from that one. What is more significant is the second category, and those are the validation requirements in Rule 6. They appear on page 134. In my submission, these terms also don't pass the high hurdle of onerousness. They form part of Camelot's rules for validating plays with a view to ensuring that prizes are only paid out for genuine winning plays.
Okay, I can see why this is relevant. Yeah.
So the relevant clause for today's purposes is Rule 6.2 Delta. This ensures that only prizes that appear on Camelot's official list of winning prizes are paid. And in my submission, there is nothing onerous about that. And then the third category...
But that's because on your official list, it would have said 10 quid.
Yeah.
But that just comes back to how you construe the tin. And if on the tin, if it's absolutely clear there should have been £1 million plus 10, and it didn't, there might be a different issue. Does it all depend on how we construe the tin?
What I take from that, my lord, is that does this all depend on the construction analysis and how the relevant contractual term fits?
Yeah, well,
Yeah.
I'm just trying to see in each of these, what is the actual nub of the issue?
Yeah.
I know one can, you know, one can have a pot at them just for the sake of it, but
Well, what I'm doing at the moment is laying the groundwork.
yes,
Because in order to approach this in my submission in a logical way, one needs to first ask the question, which terms were incorporated into the contract? And do any of the terms fall foul of the onerousness test such that they weren't incorporated by the techniques that Camelot used, the click wrap technique?
but that
If
would-
that's the case, then you disregard them. They're not part of the contract. And
but
when
we're only
you-
interested in terms which matter.
Yeah, and this is one of the terms
This is one.
that does matter.
Yeah.
This is
Because
one of
it
the
only
terms that does
records,
matter.
it records the winner's 10 quid.
As I will come to the end of the day, this is the answer to the dispute. The play number for this particular play is only recorded on Camelot's official list as a win of £10.
Yeah. Okay.
And this is therefore the critical term. The third issue that my
6.1 presumably is relevant because it's the precursor to 6.2d. It must be successfully validated in line with reasonable validation procedures,
yes,
and then you've got the validation process described in 6.2.
correct.
Yeah.
And then my learned friend seeks to argue that
I'm sorry to keep
Yeah,
just
of
looking
course.
at 6.3.
Yes,
Without limiting 6.1, Camelot may declare a play invalid
yes.
if the play is defective. Is that something you rely on? Is that something which
No, the only element in 6.3 that I rely upon,
Yeah.
but in my submission I don't need to rely on it, on the facts of this case, are E. The outcome of a play as displayed on the game play window
yes.
is inconsistent with the result of that play.
Yeah.
Now, I say that I don't need to rely on it because, in my view, in my submission, the outcome of the play that is displayed on the gameplay window, that is the screenshot that appears at page 105,
Yeah.
was a win of £10. The two £10 icons are flashing white, and there is a message saying you have won £10.
That begs the question of construction of the
It
tip.
begs the question of construction. But if this were, and in Mr. Justice Jay's judgment, he posits a hypothetical scenario of a different coding error, a worse coding error, where the screen that is presented to the customer says you've won £1 million.
Yes. Yeah. Or it animates both the 1 and the 50.
Yeah. And on those hypothetical facts, I would be able to rely upon that clause.
Yes, we understand.
And the final category that my learned friend says is onerous is the dispute resolution provision, the so-called Braganza clause. This is 12.1 on page 138. In my submission, clauses like this don't meet the high standard of onerousness. There was an argument that they oust the jurisdiction of the court. They clearly don't. There was a more nuanced argument that a reasonable consumer might think that they oust the jurisdiction of the court. Well, in my submission, the reasonable consumer wouldn't expect that that is the case, as this case demonstrates, as the fact that this claimant has brought this case to court, instead of concluding glumly that she's bound by the decision. And given how common these kind of clauses are, my lords and my lady will have seen these so many times before. A finding that they are onerous and they need a red hand in order to be incorporated would have extremely wide-ranging implications. So for all of those reasons, we say that the judge was right to conclude that the terms that Camelot relies upon were all incorporated into the contract. And I propose now to turn to the issue of enforceability under the 1999 regulations. Unless my lords and my lady have any more questions on incorporation. Now, the issue of enforceability turns on the application of the 1999 regulations to this case, so that your lordship and your ladyship have it, and I'm sure you do. Those regulations have, of course, since been revoked and superseded by the Consumer Rights Act 2015. That act applies to contracts that were concluded before the 1st of October 2015 onwards. And that is why we are considering the 1999 regulations for this case. The relevant contract was concluded in August of 2015. But the relevant regulations that are the subject of this appeal from the 1999 regulations have been copied more or less completely and exactly over into the 2015 Act, so that your lordships and your ladyship's decision will continue to be of significance for cases governed by the 2015 Act. Now, the judge correctly directed himself in paragraph 79 of his judgment by reference, that's on page 91 behind tab 7 of the core bundle, by reference to the House of Lords decision in Director General of Fair Trading versus First National Bank. In paragraph 79, he quotes paragraph 17 of Lord Bingham's speech in that case. Lord Bingham there made it clear that there are two interlinked aspects of Regulation 5. The requirement of significant imbalance and the requirement of good faith. He says that the requirement of significant imbalance is met where a term is so weighted in favour of the supplier as to tilt the party's rights and obligations under the contract significantly in his favour. And his lordship goes on to say that the requirement of good faith is one of fair and open dealing. Terms should be transparent and well signposted, and they shouldn't take advantage of the consumer. Since then, the Supreme Court has considered the 1999 regulations. It did so in Harkingai and Beavis. I invite the court to turn this one up as well, please. It's behind tab 8 of the bundle of authorities. The facts are well known. A consumer parked in a private car park. The notice said that the first 2 hours were free, but at £85 would be charged to those who stayed longer. The case has become well known for dealing with the issue of whether or not something is a penalty of common law. But the Supreme Court also considered whether the relevant term was unfair under the 1999 regulations. Lord Neuberger and Lord Sumption set out the applicable propositions of law in paragraph 105 on page 1228 of the report. And may I invite my lords and my lady to read that paragraph, please? Their lordships held, and everyone with the exception of Lord Torson agreed, that although the term caused an imbalance in the parties' rights, that wasn't contrary to the requirement of good faith. And their lordships' reasoning appears at the top of page 1230 of the report, in paragraph 107. This was because the owner of the car park had a legitimate interest in imposing the charge. The charge encouraged users to observe the 2-hour time limit, so there was space available for others. And it underpinned a financial model that enabled the owner to allow the car park to be used for 2 hours free of charge. The lordships go on in paragraph 108 to say that a reasonable motorist in Mr. Beavis's position would have agreed to the term in a negotiation. The claimant's first argument on the 1999 regulations concerns the effect of Regulation 7.2, the contra proferentum rule. And he argues that the judge erred when construing Rule 13.3 of the IWG rules in the light of that contra proferentum rule. I've set these two provisions out in my skeleton argument. It's the final tab in the core bundle, tab B2, at page 190. So in paragraph 46, you will see clause 13.3 that we looked at previously, and regulation 7.2 in paragraph 47. The argument, I think, is this, that applying regulation 7.2, the judge should have concluded that the relevant contractual term prevails over everything else. That argument should be rejected. Regulation 7.2 is a statutory enactment of the contra proferentum principle. It's concerned with the construction of individual terms which are ambiguous. It's not concerned with the reordering of terms or the disapplication of terms, like clause 13.3. In my submission, there's no scope at all for applying Regulation 7 to Rule 13.3, because there is no suggestion that Rule 13.3 is ambiguous. My learned friend suggested in argument, in oral submissions, that Rule 7.2 needs to be read in conjunction with Regulation 6.1. We would disagree with that submission. That there's no indication in the legislation to that effect. In my submission, these are entirely separate provisions, different tools in the consumer protection toolkit, which serve to further the consumer's interests. But it's not right that one should be read across into the other. And for completeness, although it's obviously not binding on this court, I draw your lordship's and your ladyship's attention to a fairly recent decision of Mr. Justice Bourne in tab 12 of the
Can you just
authorities bundle.
I'm probably being a bit thick here. Why does 13.3 matter in the overall scheme of construction? What is it that 13.3 needs to have rewritten about it to enable the claimant to win? Because his point is the box is clear, and therefore nothing in the terms thereafter can remove what's clear from the box. We've dealt with the validation requirement, which is one such, and the dispute resolution requirement. What is it about 13.3 that alters the position? I'm not discussing the merits, I'm really just discussing the structure of the argument.
That's really a point for my learned friend, but I think the answer is this. If one sees that under echo in 13.3, one of the things that is given contractual force are statements and explanations appearing on the game detail screen. The game detail screen is the screen that we were looking at earlier on this afternoon, from which the player clicks play.
It's the box as it's described. It's what's on the box. It's the first page you look at. Yes.
Well, before you get to the screen with the icons, which is post-contractual.
Okay.
This is the screen that appears in the supplemental bundle behind tab.
I see. Okay. I think I've got it now. I understand. Yeah.
And I showed you. You have to squint. But it is right, and I acknowledge that the relevant contractual term, as he calls it, appears in isolation on the game detail screen. One has to squint to see it, but it is there. And so I had understood that his submission was, I can rely on that to the exclusion or in preference to everything else, if I can get around the hierarchy in Rule 13.3. Because otherwise, he is in a situation where those words that he relies upon only otherwise appear in the game procedures, which, as I will go on to submit, must be read as a piece. One can't just focus on, one can't just cherry pick certain words.
The game procedures are the second line down in the hierarchy below the applicable game-specific rules.
Of which there are none for this particular game.
So the applicable games procedure is the highest line in the hierarchy in this case.
Yes. But as I will come to when I get to my submissions on construction, these kind of clauses, they're not unusual. When one is dealing with a contract that is made up of different moving parts. The way that Mr. Justice Jay analysed this was to suggest that what one has to do first of all is to look at the game procedures, because according to Rule 13.3, those are the highest priority contractual documents. In my submission, that's not what this clause is seeking to do. What one has here is a contract that is made up of terms and conditions that are found in a number of places. It is only if there is a conflict between the terms of those contracts that one prefers one of those documents over the other. But the starting point for this court is that the court will seek to read all of these terms and conditions in harmony with one another. We won't go looking for a conflict. The parties have agreed that all of these documents will form part of the bargain. And it is only if one finds a situation where two terms in two different documents are at loggerheads with one another that one needs to have regard to this rule. The authority that I was mentioning before this was Mr. Justice Bourne's decision in tab 12 of the authorities bundle. It's R on the application of Donegan and the Financial Services Compensation Scheme. And his lordship deals with this issue in paragraph 149 through to 151. It arose in the context of the Consumer Rights Act. But, you'll see that the wording is exactly the same. The claimant's next argument on the enforceability issue is that the validation requirements, which are key, are unfair. Unfair under the 1999 regulations. We disagree with that. We say that the judge was right when he held in paragraph 89 of his judgment that the objective of these rules is to ensure that Camelot only pays out on genuine winning plays, thereby protecting the odds and pricing structure. The clauses don't, in my submission, create a significant imbalance in the parties' rights to the consumer's detriment. They merely seek to ensure that only prizes that have actually been won are paid out. And even if they did cause a significant imbalance, they do not do so contrary to the requirement of good faith. Camelot obviously has a legitimate interest in seeking to ensure that only genuine prizes are paid out. If the position were otherwise, the odds of winning these games would be different to the odds that are advertised to the public. And Camelot might not have sufficient funds to pay out all prizes that are won. A similar conclusion to this was arrived at in a recent decision of Mrs. Justice Ellenbogen in a case called Longley and Paddy Power. That's in the authorities bundle at tab 13. I invite your lordships and your ladyships to turn that up briefly. The claimant in that case placed a bet by telephone in a horse race. The bet was £1,300 each way. Paddy Power erroneously recorded that bet as a bet of £13,000 each way. The relevant term in that case appears on page 6 of the reports in paragraph 17. And this all arises in the context of Paddy Power seeking to get out of paying a larger amount than it would had it correctly recorded the bet as one of £1,300. The relevant provision is 16.1.1. Paddy Power reserves the right to correct any obvious errors and to void any bets placed where such have occurred. The argument made by Mr. Longley was that that provision was unfair under the Consumer Rights Act. And that argument was rejected. On page 48 of the report, at paragraph 102.8, Mrs. Justice Ellenbogen concludes that the clause didn't cause a significant imbalance to the consumer's detriment because it applies only in limited defined circumstances where an error has occurred. And she further concluded in 102.10 that the clause wasn't contrary to the requirement of good faith because Paddy Power had a legitimate interest in correcting erroneous bets. The detriment that the consumer experiences is deprivation of a windfall arising from a bet made in error. We say that those same considerations apply here insofar as the validation requirements in Rule 6 are concerned. My submission, a reasonable consumer in the claimant's position in negotiations would have agreed to rules like this, or at least to the key rule, which is Rule 6.2 Delta, that you only get the prize that is on Camelot's official list. The claimant next argues that she has been irrevocably bound to Camelot's terms. And Mr. Cusa took the court to the grey list in Schedule 2 to the 1999 regulations. We disagree with that for two reasons. Firstly, the claimant wasn't irrevocably bound. She agreed when she opened her account on the National Lottery website that Camelot's terms would apply if she played any of the instant win games. And it was then a matter for her if she wanted to play those games. And secondly, the claimant had a real opportunity to become acquainted with the terms. As my lady, Lady Justice Andrews pointed out, there was no time pressure at all. She wasn't hurried on the doorstep into this contract. And as the judge rightly observed in paragraph 87 of his judgment, the terms in question are clearly drafted and well signposted. There are contents pages that are hyperlinked. There are appropriate headings. Had she taken the time to read these terms, the chances are that she would have understood them. Finally, my lords and my lady, the claimant argues that the dispute resolution provision in clause 12.1 is unfair. The judge addresses this in paragraphs 94 and 95 of his judgment. He holds there that the rule causes a significant imbalance in the party's rights to the detriment of the consumer, because the Wednesbury test is a high burden for a player to discharge. And as your lordship and your ladyship know, he's referring there to the test to be applied to overturn a contractual decision maker's decision. It's not obvious to us that, strictly speaking, the Wednesbury test does apply, given the express requirement that the decision be reasonable in order for it to be binding. But in any event...
Why isn't that Wednesbury reasonableness? I mean, one of the things about Braganza, whether one likes it or not, is that it seems to import public law notions into private law disputes by saying that when you're dealing with the exercise of a contractual discretion, you have to exercise it in a manner which isn't irrational.
Correct. Braganza arises in a context where what the court does is to imply a term into the contract. What I'm suggesting to the court here is that the position is slightly different because there is an express requirement of reasonableness. And if I were in my learned friend's position...
Are you saying that reasonableness means something different in this context?
I'm saying that it's not necessarily the same as the concept of...
Then? What is it if it's not? if it's not reasonableness in the context in which we all understand it?
Well, it's possible, my lady, that the court would simply look at the matter afresh in concluding whether or not Camelot's decision was a reasonable one.
Wednesbury is, to my mind at least, slightly confusing because it imports a public law recognition that there is a state involved with constitutional rights and there's a deference to be applied. You wouldn't necessarily import that into a contract. It may not be much difference between the two, but reasonableness in a contractual context doesn't have that state against individual context. It may or may not matter on the facts of a case.
Yes. But as I was saying,
Sorry to interrupt. I mean,
yes, of course.
Even in public law, there are straightforward public law cases where you apply a Wednesbury reasonableness test, and then there are cases where issues under, for instance, Article 3 arise, in which case the court engages its own assessment of whether what's been done, what might be done, is reasonable.
Yeah.
The only point I'm making here is that, given the express requirement of reasonableness, I don't think we're necessarily in the situation of the consumer having to establish that Camelot's decision was an arbitrary or a capricious one, or that there was some error in the decision-making process in order for it not to be, for him or her not to be bound.
Yes, I follow.
If you're right on Rule 6, that's largely going to determine the matter. If you're entitled to a validation process, there wouldn't be much left of a reasonableness analysis.
That's right.
Can I just ask you why? I mean, maybe because you're trying very cleverly and quite properly and forensically to avoid Braganza, but you're not submitting that 12.2 was an ouster of jurisdiction. Why?
Well, because in my submission it isn't. And sorry, did your lordship say 12.2 or 12.1?
I'm just looking at paragraph 94 of Mr. Justice Jay's judgment. Mr. Hanks did not submit that clause 12.2 was an ouster of jurisdiction.
I think that's it's a typo. It should be 12.1.
Should be 12.1. Okay.
12.1.
Repeat the question. 12.1. Why are you ducking the point about ouster? Forensically very clever, I agree with that. Sensible, strategic.
But in my submission, when one has a clause like 12.1, it doesn't oust the jurisdiction of this court. The court is able to assess, and this is the conversation that we've been having.
Yes.
When a decision has been taken, when a discretion has been exercised, whether that was a reasonable decision, so as to be binding. But
let's assume it didn't have the reasonableness caveat in it.
Yes.
Would you have made the same concession?
Well, no. My concession would be slightly different. What I think would need to happen in that scenario is that the consumer would need to establish that Camelot's decision was an irrational or an arbitrary one or a capricious one, or, as might be easier, that there was some flaw in the decision-making process such that the decision can be seen to be an insecure one.
So suggesting, therefore, that even if the reasonableness caveat wasn't there, it still wouldn't be an ouster of jurisdiction?
Not an ouster of jurisdiction. So even in strict Braganza cases, where the term is implied, the court retains a discretion, not a discretion, a jurisdiction to supervise the decision maker's exercise of its discretion, to make sure that in a public law sense, as my lord has pointed out, it was a proper decision to be taken.
Yes, thank you.
But in my submission on the facts of this case, the complaint about Rule 12.1 doesn't really go anywhere, because it only really comes in terms of Camelot's assessment of the validation requirements and whether or not this particular play was on the official list as a win of £10 or as a win of £1 million. In this particular case, there's no discretion that Camelot has exercised for your lordship and your ladyship to assess the reasonableness of. All Camelot has done is to look at what is on the official list and say, it's £10. Now, there will be different cases. There will be other facts. So, for instance, going back to the IWG rules behind tab 10 and looking at other parts of rule 6.2, for instance, Camelot will declare a play invalid if the play is the result of an act by you that was intended to increase the chances of you winning a prize. One can readily see that that is something that might require more of an assessment, a discretion being exercised, that would lend itself to these kind of considerations and whether or not the court should interfere with them. But the validation issue
You just simply say this is automatic, instantaneous.
is binary.
It creates a result, it's yay or nay, and it goes into the list. So there's no discretion to be exercised.
My lord has the point. I'm going to now move, if I may, to the final issue of construction. In my submission, the position is straightforward. The solution to the dispute lies in Rule 6 of the IWG rules. The relevant rule is 6.2 delta. That ensures that any prizes that are on Camelot's official list are paid, and on the official list, the prize is £10 and it has already been paid. And one reaches that conclusion, as we've just been discussing, whether or not one, even if one disregards Camelot's decision to that effect, and the court decides the issue for itself. In other words, we don't need to be in a situation where the claimant is bound by Camelot's decision, because this is a binary issue. Now, the claimant's submissions on the construction issue focus on what my learned friend calls the relevant contractual term, to the exclusion of all others. And in my submission, that approach is simply unsustainable. One can't simply cherry pick and ignore the remainder of the contractual framework, assuming that the court is with me on issues of incorporation and enforceability. I showed your lordship and your ladyship earlier that a similar slogan appeared in the O'Brien case, which said, match two identical cash amounts you've scratched off on today's section of the card and you win that amount. And there was no suggestion in that case that those words should be enforced to the exclusion of the other terms. Aside from appearing in very, very small text on the game details screen before she clicked play, the only other location where those words appear is in the game procedures at page 144 behind tab 10 in the core bundle. And what it says there is, at the bottom of the gameplay window are the instructions: match any of the winning numbers to any of your numbers to win a prize. But that's not obviously not all that the game procedures say. The game procedures need to be read as a whole, and the final two paragraphs make it clear that if you match two winning numbers, they will turn white and flash, indicating you've won the prize for the matched your numbers. And when you've revealed all the numbers and prizes, a message will appear at the top of the gameplay window, indicating the amount that you've won. Now, as between the IW...
Just looking at, I mean, I'm just,
Yes.
these are the words on the screen that is in the screenshot in the judgment.
Yeah.
So, and they're in a number of places in the documents. So match any of the winning numbers to any of your numbers to win prize. Find a, then you've got the cash bag symbol to win that prize automatically. Find a, and a coin, double sterling symbol to win double the prize shown. So if those are the essential words, as it were, on the so-called box, you've got 3 paragraphs. So match winning numbers to win prize. Then you've got the animation, 2 different types, one which is a cash bag and the other is double sterling to double the prize shown.
Yeah.
Now, if you were construing that as the contract, without having to refer to anything else, and you read it, then the question for us is whether you read the first sentence without regard to the second and third sentence. Second and third sentence at this level appear to suggest that for the prize to be won, there needs to be an animation. And if there's no animation, there's no prize, but there will be a prize shown. And we've seen the screenshot which says £10, and we know that the wands were not animated.
Right.
Now this is part of the game's procedure, which you can click through to,
Yes, that's right.
The hierarchy as well.
and it's the top of the hierarchy on the facts of the case.
Yeah.
But just taking those words in isolation, the appellants say that you effectively look at the first sentence, you say you look at the second and third sentence, and although yes, it's just as a matter of construction, applying a purposive construction, you have to ask yourself whether or not it is just the first sentence, or whether or not a demonstration of that wins involves an animation on the facts of this case. I mean, we know if you don't have an animation, you go to a page after that, which simply gives you 10 quid.
Yeah.
Because that would reflect the validated figure.
In my submission, the reasonably construed, and if one were looking at the game procedures in isolation, without regard to anything else, one would come to the conclusion that the winning amount, the amount that you have won, is that which turns white and flashes in a green circle.
Well, then on paragraph 14 of the judgment gives us the screenshot, and you can see that the 15s are animated and the ones are not.
Yeah.
Not just that which is white turns white and flashes, but that which then ends up in the message that you get when you click on.
Exactly.
And then in the top right-hand box, you have won £10.
Yes.
In my submission, it's tolerably clear that when it says, when you've revealed all numbers and prizes, a message will appear at the top of the game, indicating the amount you have won. Does my lord have that?
Yeah.
But perhaps a more important submission is that it would not be right to just look at
But
the
at
game.
that point, it was not on the screen itself. That's in the game's procedure. That last bit, it tells you that when you press, it will come up on the top right-hand corner.
Yes.
But we can see from the screenshot screen that we've got that. We know what's animated. We know what the end result is, and you can screenshot the ones and see that they're both there.
Yeah.
But that same document tells you you've won £10 and only 2 are animated.
Yeah.
And it says finish, congratulations, you won £10. And we know, because it's common ground, that the synchronicity of the ones is an error.
Correct.
And those are the salient facts from which one looks at what. Well, it seems to me those are important facts when one looks at reasonableness. What construing that document there, a consumer would reasonably believe were the relevant terms.
With respect to my lord, I don't think that's the relevant question. There are a number of issues here. First of all, what terms are incorporated?
I absolutely understand that. I'm just looking at that front page, saying what would I have deduced from it? It's about the relevant terms. And I know when you go back into the terms and you click down, you'll see various things. I'm not certain they'd be inconsistent with my interpretation of that front page. Namely that There was something odd about the synchronicity of the wands, but I knew that my 15s were flashing, and I know I'd won 10 quid.
Of course, we need to look at this before one gets to the game play window, which is after the contract has been entered into. And the issue for my lords, my ladies, what are the applicable and enforceable terms? And in my submission, no reasonable consumer would think that the entirety of their relationship with Camelot is governed by the minuscule words that appear on the game details window. The reasonable consumer would have appreciated, because of the process they went through, the player's journey, that there were other terms and conditions. And had they clicked on the drop-down menu, that would have become apparent. In my submission, what we're dealing with here quite clearly is a contract that is governed by a number of documents, one of which is the game procedures, and the other are the IWG rules. And although, as we've been saying, the game procedures have primacy over the IWG rules, as I stated earlier, that is only the case where there is a conflict in the terms. What one needs to identify is a term in the game procedures that is in direct conflict and cannot be reconciled with the term in the IWG rules. And that isn't the case here. There's no conflict between those two documents. The validation rules in the IWG rules apply to all of the plays. And there is nothing in the game procedures to suggest otherwise. And pausing there, that it would be very unusual. It would be very unusual if that were the case. So applying all of those terms to the facts of the case, we say, as I started these submissions, that the answer really does lie in the application of the validation rules, in the IWG rules. And it is clear from the application of those rules that the claimant has won a prize of £10. My lords and my lady, those are my submissions, and unless I can assist you further.
This probably hasn't got anything to do with the terms of the contract, but just out of interest, looking at the judge's the judgment, which if one place we can look at it at A77 in the core bundle. That's a screenshot that the claimant preserved. At some point, she had clicked on various icons, brought up the various numbers. As a matter of mechanics, how did the two 15s light up? Is that just the operation of the computer program, or was that some activity act on her part?
No, my lord, my understanding is that it's the operation of the computer program.
Yeah, well, I assumed it was, because otherwise she'd have tried to click on one and one.
And I take that from the game procedures.
Yeah.
That says the two matching numbers will turn white and flash.
Yeah.
In other words, the use of the passive tense indicates that this is something that the computer is doing.
Yeah.
And not the player.
So the player gets to the position which is in the screenshot, and then the computer decides from predetermined numbers whether she's won anything.
Yes.
And in this case, the predetermined figure was £10.
I'm told by Mr. Smith, who sits behind us, that this is one of the XML instructions, the extensible markup language instructions, so part of the coding of the game.
Thank you very much.
Thank you very much indeed, Mr. Kazan.
My lord, just a few short points. My learned friend, very close to the beginning of these submissions, took you to page 118 in the supplemental bundle, and it may be rather than a submission, it's a matter he can clarify, because what he said to you was, you look at page 118 supplemental bundle, you don't in fact have to reread everything, you just reread parts that have been updated. And I'm afraid I can't see from page 118, or I don't believe it's anywhere in the evidence, that it says that. What it says is, we've changed some of our important documents, rewriting them to make them shorter and easier to understand, and also to reflect changes to functionality on our new website. We'll need to read about and accept the changes to confirm you agree to be bound by the revised account terms and rules. Choose to finally be signed out of the site and will be unable to pay online. It doesn't say that they're flagged in any way. My reading of that is you're going to have to reread everything to see what it is they have changed, and perhaps by reference to what it said before.
It's a summary of changes.
I thought what he told us was that there was a drop-down menu. So what you've got is that you've got a summary of changes with a drop-down menu that will take you to the summary. And then if you click onto the drop-down menu, you get the summary of the changes for each particular bit that's being changed. And then there's a hyperlink which takes you through, I see Mr. Smith is nodding, a hyperlink which is taking you through to the full changes, so that you've got the full changed version of the rules, but the actual main changes will be highlighted and summarised in the drop-down menu.
Well, I hadn't appreciated that, but I'm grateful for...
That was my understanding from what Mr. Hinks told me, and seeing the expressions on the people sitting behind him, I think I'm right about that.
Then they're all nodding, so yes. The other point you made at the beginning of the submissions was that animations may be disabled, and I absolutely accept that the game can be played with the animations disabled. That is in fact a red herring, however, and don't place too much weight by it, because either Camelot are in breach of contract or they're not. The fact that the player might not have known that they're in breach of contract because they've disabled the animations can't alter the contractual position, it seems to me. Either I'm right or Mr. Hinks is right on the main submissions, and the animations being disabled is a complete red herring. Now, a further point that Mr. Hinks made on a number of occasions was that the relevant contractual term, when one looks at it in the screenshot, for example, in the judgment, page 75 of this, is very small. I think he said, I can only just make it out, it's in minuscule writing. Well, there's a couple of points about that. The first is that we know the game is capable of being played on different platforms, and what you look at on a little phone screen might appear small, but what you look at on a big 50-inch monitor will appear otherwise. Plus on phones and what have you, we're all, I think I can invite you to take judicial notice of the fact that you can zoom in on these things these days. So again, the size of it isn't really determinative of anything, but in particular, Camelot are the people who choose how big or small to make what it is they print, and that's the only thing they put there on the tin, as you put it, my lord. And so it can hardly be set up as being a defence if it's too small when they made it that way. So again, I'd invite you not to put too much weight by that. I'll deal with a couple of the authorities my learned friend took you to. The first is O'Brien and MGM at tab 3. O'Brien is a slightly odd case because it's a consumer contract case, because clearly Mr. O'Brien bought the newspaper and bought into the scratch card game that's being played. The contract itself was formed, you see this at page 38, letter C of the judgment. The contract was formed on the 3rd of July 1995, so clearly it predates the 1999 regulations. But the 1994 regulations came into force on the 1st of July 1995. And so they were in force, and for these purposes, were largely identical, but for whatever reason they weren't argued before the Court of Appeal. And I simply don't know why that would be. They don't appear to have been cited. One side was represented by leading counsel, but they just appear to have been overlooked. And so
It was only a matter of days before that they came into force, so maybe that's forgivable.
it's a matter of 3 months, I think, my lady.
Was it?
Yeah.
I thought you said they came into force in
Well,
July.
so contract formed on the 3rd of July, and the oh, I'm so sorry. It is a matter of days. You're absolutely right. It's a matter of 2 days. No, you're quite right. Well, that
It's
may be
still
the-
shocking,
Hmm?
but still shocking.
Outrageous that leading counsel didn't know that it had come into force 2 days
Well,
ago.
you know, well, I'll leave what I was going to say, but the point about it is that really the point I can properly make is that the Court of Appeal didn't receive the assistance
No.
it was entitled to receive.
Yeah.
And had it have done, the matter may well have been decided differently. I'm not going to speculate on that. What I do say is the best that one can say about O'Brien is it's decided per curiam, because the relevant legislation hasn't been cited. When dealing with the point about ouster of jurisdiction, and I know you have my point on that, that it's what really counts is that not whether or not it has been ousted, but rather what the consumer is told about that. My lady friend made the point that, well, the reasonable consumer knew it wouldn't have been ousted because look at Mrs. Parker-Grennan, she's brought this case. Mrs. Parker-Grennan didn't bring this case in 2015, I'm sorry. And she left it until actually Betfred was widely publicised before she emerged. Because at that point, I'd invite you to infer, what popped into her head was, hold on a second, I was told I couldn't do anything about it, and someone else has. So I don't think saying the reasonable consumer would know that the jurisdiction hasn't been ousted because of this case actually holds water.
One might say that Mr. Hinks was engaging in speculation, and now you're giving evidence that we haven't got.
I obviously have to accept that, but it's certainly common ground, and I think there is correspondence within the bundle, which I can ask my learned solicitor to look up while I'm making further.
We still haven't got evidence from the claimant.
No, but that's true. All you have. Bear with me, my lord. And then my little friend took you to Paddy Power, the Longley and Paddy Power case, which is tab 13 of your authorities bundle. The distinction, I think, is this, which is that in the Paddy Power case in Longley, what you have is an obvious error about the amount that's been paid and what should be done about that. Here, Mrs. Parker-Grennan has paid exactly that which Camelot asked her to pay, and that deals with the point about reliance. It comes out of paragraph 102.10 because she's done exactly what it is that it says on the tin, if we can continue to use that analogy, whereas there was an error over what had been paid. I mean, well, I won't speculate, but in any event, when one comes to 102.10 of the judgment, further accept Mr. Under the submission, Paddy Power has a legitimate interest in correcting erroneous bets. That's different here because whilst I'm prepared to accept that Camelot or any business has a a legitimate interest in its pricing structure and protecting the integrity of that, there are well-established means for doing so. And we discussed those briefly in argument, insurance, looking to pass the loss on to those who are actually responsible for it if there is someone further on the chain, such as a software firm, who've been responsible for this. So I do say this is quite different because here, unless Paddy Power is going to go to whoever the telephone operator was and say, right, you've got to pay out the difference from your doubtless meagre salary, Paddy Power perhaps doesn't have that ability. I'll just bear with me one moment. Now, there was reference made to the judgment of Mr. Justice Jay, where I think he refers to clause 12.2. The decision was probably a typo. It may not be. We didn't take it to 12.2. But if you go to the core bundle behind tab 10.
This is whether it's an ouster clause or not.
That's right, yes.
Yeah.
So it's 12.1 is set out at page A138.
Does it matter? Because it's not said against you that that clause in any way ousts the jurisdiction of the court. You haven't been prejudiced by it.
But I'm going to take you to 12.2, where again, what it appears to do is oust the jurisdiction of the court, because it may be that Mr. Justice Jay is not a typo.
Right,
And that's at 139.
Yeah.
The remedy in Rule 12.1 will be the player's sole and exclusive remedy, and any reimbursements or replacement will fully discharge Camelot from any liability in respect of such a dispute, subject to Rule 12.4. Camelot will not be liable to pay any interest in respect of any reimbursement made under this Rule 12.
I see. So it could be construed as an ouster of a limited sort.
That's the very point, yes.
Yep.
May I turn my back on you?
Yes, of course.
Very grateful.
Thank you very much. That brings us to the conclusion. Can we thank counsel and those behind them for their assistance today? We will, of course, reserve judgment. We will produce in due course a draft judgment for editorial changes. As everybody knows, it's not an opportunity to make further submissions. Can we remind people of the confidentiality undertakings that will be required in relation to the judgment? It may apply more to Camelot than to your clients, but if anyone within Camelot considers that somebody else needs to see it, you need to seek the permission of the court for the draft judgment to be provided outside of the approved circle. Can we thank everyone very much indeed for their assistance today? Thank you.
All rise if you're able to.